5 seconds to go. Start. A hostile witness is described as one who is not desirous of telling the truth at the instance of the party calling him, and an unfavorable witness is one called by a party to prove a particular fact in issue or relevant to the issue who fails to prove such fact, or proves an opposite fact. Stop. In the context of sections 142 and 154 of the Evidence Act, this court observed in paragraphs 38 and 52 as under, para, to steer clear of the controversy over the meaning of the terms hostile witness, adverse witness, unfavorable witness, which had given rise to considerable difficulty and conflict of opinion in England, the authors of the Indian Evidence Act, 1872, seem to have advisedly avoided the use of any of those terms so that, in India, the grant of permission to cross-examine his own witness by a party is not conditional on the witness being declared adverse or hostile. Stop. Whether it be the grant of permission under section 142 to put leading questions, or the leave under section 154 to ask questions which might be put in cross-examination by the adverse party, the Indian Evidence Act leaves the matter entirely to the discretion of the court. Stop. The discretion conferred by section 154 on the court is unqualified and untrammeled, and is apart from any question of hostility. Stop. It is to be liberally exercised whenever the court from the witness's demeanor, temper, attitude, bearing, or the tenor and tendency of his answers, or from a perusal of his previous inconsistent statement, or otherwise, thinks that the grant of such permission is expedient to extract the truth and to do justice. Stop. The grant of such permission does not amount to an adjudication by the court as to the veracity of the witness. Stop. Therefore, in the order granting such permission, it is preferable to avoid the use of such expressions, such as declared hostile, declared unfavorable, the significance of which is still not free from the historical cobwebs which, in their wake bring a misleading legacy of confusion, and conflict that had so long vexed the English courts. Stop. Para. From the above conspectus, it emerges clear that even in a criminal prosecution, when a witness is cross-examined and contradicted with the leave of the court, by the party calling him, his evidence cannot, as a matter of law, be treated as washed off the record altogether. Stop. It is for the judge of fact to consider in each case whether, as a result of such cross-examination and contradiction, the witness stands thoroughly discredited or can still be believed in regard to a part of his testimony. Stop. If the judge finds that in the process, the credit of the witness has not been completely shaken, he may, after reading and considering the evidence of the witness, as a whole, with due caution and care, except, in the light of the other evidence on the record, that part of his testimony which he finds to be creditworthy and act upon it. Stop. If in a given case, the whole of the testimony of the witness is impugned, and in the process, the witness stands squarely and totally discredited, the judge should, as a matter of prudence, discard his evidence in toto. Stop.